Good afternoon, everyone. Welcome to the 18th episode of ICC Biz Live, a very popular show among the business people. Today, we have with us two expert lawyers who will be talking business because in any business ends in contract, and if the contract is wrongly worded, it is business which will suffer. So we have Madam Kalpana Muthireddi, who practices both in India and US. She is a dual qualified business lawyer licensed in both India and New York with over 15 years of experience advising on high stakes cross border contracts, technology transactions, and legal strategy. Nowadays, we have much of FDI flowing abroad. So, in such a scenario, we need lawyers who would evaluate cross border contracts. Banner Kalpana has worked with Fortune 150 companies, global tech leaders, and scaling ventures across jurisdictions and has prior experience as a litigation lawyer at the High Court of Karnataka. She is a Dean's List graduate with an LLM from the renowned Vanderbilt Law School from US, a master's in business law from National Law School of India University, and she's also the author of Legalese Decoded Tips and Strategies to Make Sense of Legal Concepts in the Business World. This is readily available in Amazon.in. It's a business focused legal strategy guide that has earned appreciation for its clarity and impact so much that some of our clients use it to train their in house legal teams. She has also contributed to externally acknowledged work such as a Scopus Index book on blockchain law, publish internationally global policy and strategies for blockchain building ecosystems and sustainability. She is known for a preventive approach to law and going beyond merely fixing what's broken and ensuring the business scale without stumbling into legal traps. Today, the topic is quiet killers in large-scale commercial contracts, and we have with the right person to talk with Advocate Shayak Chakraborty, our renowned advocate of Calcutta. West Bengal. He is a mentor of the Advocate General of West Bengal, barrister at law and senior advisor advocate Jayanta Kumar Mitra. He's an advocate of Calcutta High Court, mainly practicing civil and constitutional matters. He's also an impanel advocate for the state of West Bengal. He's an avid debater and had founded the Debating Society of Gujarat National Law University while studying law there. So over to you, Advocate Shayak, and now to take over the medicine.
Thank you very much, Dr. Ghosh. And as he pointed out, the topic is quiet killers in commercial contracts. So I just throw it open to Kalpana ma'am to enlighten us. What exactly do we mean by quiet killers in commercial contracts?
Good evening, Shai. Good evening, Dr. Ghosh. Thank you for that generous introduction. And thank you to the ICC for having me. So, hello, everyone. I'm Kalpana Muthireddi, and I'm delighted to be here with you. Today, we're going to dive into a topic that's rarely discussed in depth, but it costs businesses quite a lot in terms of losses and risk. Um, every year. So I'm keeping this session at a very basic and intermediate level and completely avoiding legalese. So which is why I use terms like white killers, which are not technically legal, so to say, but they tend to send the message across quite clearly. So the idea is I'm going to share some of those clauses which are pretty standard across board, but then they tend to pack quite a lot of risk within. And unless you're sure what you're signing up for, you could be in for a bit of a nasty surprise a few years down the line. So this particular session is going to be, like I said, a slightly basic and intermediate level so that you have a basic and fundamental understanding of this topic and your risks, and you're able to use these strategies that I'm going to share with you right away. So what I'm talking about are those hidden traps buried in commercial contracts, and they look quite harmless on the surface and couched in very innocuous terms and verbiage, but they can do quite a lot of damage. That is why I call them the quiet killers. And by the end of this session, you will know exactly what to look for, what to avoid, and how to protect your business before it's too late. But then, before that, a word of disclaimer. Please be informed that this is a merely informative session and is not legal advice, and please don't construe it as such. If you do have specific concerns, please contact your lawyer and take appropriate legal advice. So let's get started. So to start with, what we call the quiet killers in business contracts. Now, I said large commercial contracts, but to be honest, these clauses can be found anywhere in every contract across board. They could be the regular general contracts you enter into with your B2B partner, or they could be your B2C contracts. Not necessarily international, but quite local as well. So, the first thing I would want to tell you is, so what are these quiet killers? Or why do we need them? And what to do when you identify them? So that's going to be the first part of this session. And then I'll move on to the big quiet killers themselves. I'm going to discuss a few of those clauses, maybe five or so, because we have a time limit to adhere to. So I'm going to take out the big ones, which usually tend to pack a little bit of a risk within, and then discuss those clauses. And then we move on to a questions and answer session, which Shayak would be asking some questions and I'll be answering his queries. So that would be part three of this session, where we are specifically delving a little deeper with those questions. And then we have something called these strategies to deal with this kind of quiet killers. What kind of processes you should have in place? How do you identify them? How do you make sure your teams within understand what this is, and how do you get that support and buy-in from your internal departments? It could be your business, could be your finance, could be your general C-suite executives. And then we end the session with, if you have a few questions, I'll be happy to answer them for you. So that's basically the overall outline of this talk today. And let's start with the quiet killers. Now, before I start, there's one thing I'd like to tell you, and that is I made a copious amount of notes in preparation for this session. So please don't mind if I'm referring to my notes as we speak. Now, coming back to this. So what exactly are quiet killers? So these are clauses which are generally found in every agreement, and they could be what we call important clauses, the big ticket items like indemnities, LOL, intellectual property. They always pack a good amount of risk with them. But there are also those seemingly innocuous clauses which seem like standard text. Sometimes they're in the miscellaneous section, sometimes they're in the payment section, sometimes they're in the general reps and warranties sections. So how do you understand these clauses? How do you know what to look for? And what do you do once you identify these killers? Now, the second thing is, okay, why do you need these quiet killers? One might think the answer is obvious. Well, you want to make sure your contract is safer at the end of the day. But what exactly does it mean if you do not have any approach to deal with these clauses? Well, the first thing that could happen is you could end up with a contract not knowing what you have in there, firstly. And secondly, you could be signing up for something which could eventually cause a lot of damage. It's very common to understand or recognize that a simple clause could actually sink a deal. It's not unheard of, and it is quite possible. So it's very important for you to understand what these clauses are, how to deal with them, and then what to do when you've identified those clauses. So before we move on to that, I'd like to start with the clauses themselves, what I call the big, quiet killers and the big ticket items. And these are, I'll start with the big ones first of all. Um, there would be the indemnity clause, the limitation of liability clause, and the others. But before we start off, I'd like to tell you a case, case study or a very famous instance of what happened when a seemingly innocuous mistake led to massive damages. So this is 1990s, and the case relates to Pepsi. So sometime around mid 1990s, PepsiCo released a promotion, an advertisement saying we're offering a points for prizes. promotion. That is, you get Pepsi points, you buy a Pepsi, you get those Pepsi points, and then you exchange those points after accumulating them for a prize. So one of the prizes, in fact, the biggest part of the promotion was uh, a prize advertised for 7 million Pepsi points, and that was a fighter jet. A Harrier fighter jet valued at around 700,000 US dollars was offered for 7 million Pepsi points. Now, Pepsi knew that this was just an advertisement, and it was just a joke, a running joke within Pepsi, where they said nobody's going to get 7 million points. The idea is to just send the message across that our prices are pretty good, and this will grab a lot of attention. However, one person, a student, around a 21-year-old student by the name of Leonardo, managed to buy those 7 million points, and he went to Pepsi to ask for the fighter jet. Now, that was something nobody expected. Remember, we are in 1990s. This is at the height of the cola wars. PepsiCo and Coca-Cola were in a fierce battle to capture the market. So this was not going to be easy for Pepsi. But then they had to refuse because, as the judge said, you cannot possibly offer a fighter jet. A private entity like Pepsi cannot offer a fighter jet to an individual. That's absolutely out of the realm of normalcy. But then Pepsi made the statement out there. So here is where I want to stop for a minute and tell you what's happening and why it relates to what we're talking today. Anytime you put out an advertisement, it's the same as offering something to the public. This is especially true in B2C, or where you're going to the general public with your advertisement saying, hey, we have something on offer, this is what you need to do, and this is what you'll get. Pretty much, Pepsi was offering a fighter jet in return for Pepsi points, right? And the moment the person accepts the offer, you have a deal which is legally valid and binding on both parties. Now, what Pepsi did not consider and would not have even thought was somebody coming with this points, and there was one small clause or one small phrase that could have saved them, and that is something that says an asterisk saying for promotional purposes only. Now, that was in hindsight, that was what they should have done, and they did it eventually when they came back with a second ad, but they had to see a lot of litigation, expensive litigation. They had to hire expensive lawyers. They won the case, but then they had to end up in a settlement with Leonardo. So what are we seeing here? Now, the lawyers didn't expect this. The judge didn't expect this, but he made a strong point when he said, when you're putting in these kind of clauses, make sure that you know, or when you're putting in these kind of offers, make sure that you know what you're doing. Now, again, I'd like to tell you, anytime you're putting out something into the market, anything into the market, even B2B, be very sure how your contracts and clauses are going to be interpreted. Is it open to misinterpretation, or is somebody looking for loopholes so that they can take advantage of them? The people
So,
can
what
exploit.
are the clauses that we need to keep in mind, particularly in case of these commercial contracts? What specific clauses do we need to particularly look out for?
Yeah. See, there are some of the big ticket items, like I said, indemnities and liabilities clause, but then I'll run you quickly through a few other clauses which are seemingly innocent, but then they can also take you quite a few notches down if you're not careful. So let us start with indemnities and LOL. So with indemnities, what happens is the first thing you need to look for is what are you indemnifying? Now, again, with an LOL clause, you have your contract is valued at, let us say, 1 crore, and you or uh, let us say 10 lakhs, and you are trying to limit your obligation or your limit your risk under that clause to an amount of, let us say, maybe 1 crore, the full value of the contract, or maybe a part of the contract, or two times the contract. You're having a specific fixed amount at which you're limiting your damages and risk. So if everything goes down the drain, in terms of liquidated damages, your total loss here will be the value of the contract, 1 crore or 2 crore or whatever amount you mentioned. That is where you're looking at when you're limiting it. So, but with indemnity, what happens is There is no such limit, but this is not simply a monetary loss. So it's also about doing everything you can to make sure that the other person is in some way remedied, in the sense they have a proper redressal, and that is not necessarily in giving them money. It's also about making sure you do certain things. If they have lost a right, make sure you go and reassert their right, make sure you approach the right authorities, and you have to do the whole thing to make sure the person is in a way seeing a redressal. So now, with coming with these two again, with LOL, there are a few things you need to look for. Firstly, are you capping your LOL limits? Like I said, you have a deal that is worth 1 crore. Are you limiting the LOL? The limitation of liability. Is your liability limited to a certain amount? It could be any amount, doesn't matter. As long as you're okay with it, it is fine. Sometimes you see in an LOL clause that the other side is limiting the liability to maybe a certain amount or a value of the project which is being executed. But you, on the other hand, are either not having a cap, your liability is unlimited, or you're having a value twice or thrice the value of the agreement. So that's something you might want to look at and try to make it mutual. Say, both of us are going to cap it at the same level in terms of maybe the value, or maybe two times the value or whatever. So that's one thing you need to negotiate always. And the second thing with LOL is exclusions. Often certain elements of the claims are excluded from LOL. Those are what you call consequential damages. Usually they're excluded, but you also need to make sure that you don't exclude a lot of those claims again from the LOL cap, because what you're essentially doing is you're putting those risks at an unlimited level. So you're looking at unlimited damages for some of those items which could otherwise have come within the cap of your liability. So that is as far as LOL is concerned. Now coming to indemnity, so
The
this is
LOL, the limitation of liability clause, it needs to be something which both parties will feel that it's not unfair to either of them.
exactly, so that's the point. But then this is what you're looking at. We are looking at those clauses which, if you're not careful, there are instances where the other party would want to limit their liability to maybe certain fixed amount, and they might say yours will be a certain different amount, or the value of the project, or something something something. So it is one of those clauses which you have to look at, because if you don't, there's every possibility that the other party could be having some terms to their advantage. And this is a danger, especially in those clauses or contracts which are coming from entities like the government entities, authorities, standard firm contracts as they call them, which they say, you just sign it as it is. We don't encourage any kind of negotiation. So you got to be a little careful, and that's one area to look at. These are what I call the big ticket items: LOL, indemnities, IP rights, confidentiality, and then uh, you have things like termination clauses. So these are the big ones, and then we will go on to some of those lesser known aspects of contracts, which again could be quite dangerous. So we're done with LOL. Now we're coming to indemnity, where LOL is largely for breach of contract or anything that happens in the course of the execution of the project. Indemnity, on the other hand, you got to make sure that it is highly quantified and highly, I would say, regulated in terms of you not giving indemnity for everything. Sometimes I've seen contracts asking indemnity for breach of contract, which wouldn't make sense because you're already having a liability clause that will take care of, any breach. So the first thing you do is remove breach of contract claims from the indemnity. Indemnity, like I said, is not merely a financial risk or an obligation. It's an obligation that goes beyond financial risk or liability. Uh, so the first thing you do is take out any breach of contract claims out of it. Secondly, you have things like breach of confidentiality. Now that's a big risk. So people need the comfort to know that if my confidential information is with you, I need to know that you're taking good care of it. And if you're not taking good care of it, you will have to indemnify me if there's a breach. So that's one. Confidentiality is one thing that can go with an indemnity. You have intellectual property rights, breach of IP rights. So that's something that you can give indemnity for. And thirdly, loss of life or limb. Let's say somebody, you're working at a client's place and something happens there and the person gets injured, loss of life or limb. Again, that gets indemnity covered. So these are the three main heads which I normally offer indemnity for. Other things, some might want indemnity for violation of laws, which I generally do not offer. I'd like to hear why they want it before I even agree to offer. So these are the main heads. And then again, regardless of what you're offering, I want you to know one thing. What is that thing? Is it that you're offering indemnity for? Firstly, no. Is it under your control? Are you able to control? You can control your employees. You can control your physical premises. You can control your systems, your the system on which your confidential information or your customer data is stored. So these are things that are under your control. Two, is there something you're able to do about it? So are you able to monitor that information regularly? Yes. Do you have a duty to monitor it? Yes. And have you done it? No. Well, you're liable for indemnity. So you got to make sure to understand what the clause is saying. If it says you have this obligation, you got to make sure, okay, is that obligation something that I'm bound to do? Is it something I'm capable of doing? And is it something if I don't do, there is bound to be a loss? That's something that can fairly come within the indemnity clause. And like I said, these are the three main heads I talk of, which you can offer indemnity. But if something else beyond this steps in, you got to be very clear why it's being asked and what the implications could be for you. So
So
that's
basically,
indemnity.
you need to be very sure that you are only indemnifying that which is within your control. You can't be indemnifying the other party for something which you can have no control over at all. When it's only
Absolutely
if
not.
you can do something, that's when you can indemnify.
Correct. And now here's one interesting clause you will see often, which says the party A agrees to defend hold harmless the party B for any and all claims arising out of. That's a standard clause you would see. The wording here is quite vague, and that's something you should avoid. And avoid making these clauses so vague and so broad that anything and everything can come within the description of any and all. So what I would want to do is when you're talking of indemnity, you say don't say you will defend and hold them harmless without knowing if that clause or that claim is really a proven claim, if it is genuine, because anybody could make a claim against you and you come to me and say, hey, you know what, there's this claim, somebody's claiming you cheated or sorry, you breached their IP, and I need to know what the breach was. If it's a simple claim, I have no obligation to indemnify you. So it has to be a third party claim, a proven claim which has been proven to have been my mistake. It's something my mistake. If it's not my fault, I'm not doing anything, I'm not responsible for you. So the way you word the language is where you're tightening the language, removing the ambiguity, and then making sure your risk is greatly reduced, and that makes your contract a lot more, I would say, viable. Even 5 years down the line, nobody can interpret it the other way. So that's as far as indemnity is concerned. I'll quickly run you through a few other clauses so that you get an idea what you need to look for and how to address them. The third thing is IP ownership. Now, this is becoming very important these days because largely because of the growing technological innovations and the fact that every area that has something to do with technology is IP dense. So you need to know where your IP rights start, where they end, how to assert them, and what to do in case of claims. So the one thing with IP ownership is, and today, conversely, we see that startups especially, and this is not as much a concern with large entities, but startups and the medium and small scale industries usually don't give this much importance to IP because it's a slightly technical area. What you need to do, however, is these are clauses again, and you have a lot of jargon and technical language there that you tend to ignore it and hope things are fine. But what you need to do there is make sure that the IP is clearly defined. Understand what that IP means for you. Understand what it means in terms of obligations, and what happens if any of those obligations are breached. What happens if you breach the obligations? and what happens if the other side breaches, which means you're looking at your rights to assert your IP, and secondly, you're looking at your obligations in case there is an IP. There's something you're supposed to have done and you've not done. So the first thing you need to do when it comes to IP is be very clear and define the IP and the scope of the IP. So this becomes all the more important and also a little, I would say, complicated when you're looking at joint IP. You're developing IP jointly. So you need to be very clear how you're going to assert that right, how you're going to set it out on paper. Secondly, when you're offering, creating a deliverable to a customer where you're using your own IP. See, when you're going in as, let us say, a company creating software solutions for a customer, you're creating a deliverable, but you already come with some residual knowledge that you've had. And that is something you would be using to create the IP. So sometimes you see that there is a clause, and I think that's a very good clause, where you say parties recognize that each party comes into the contract with its own IP, and it will use that IP to create the deliverable and will continue to have and retain its intellectual property rights over that deliverable to the extent of the IP that it brings in, which simply means even if you have created a work for hire product for a customer, make sure that as far as your IP in this is concerned, you will continue to have a right. So what it means is just because you put in your IP into a customer deliverable, it cannot stop you from using that IP for other customers, right? So you can go ahead and you're in business. You need to be able to use your knowledge. And intellectual property is today very expensive knowledge, and it's very precious in terms of using it as a commercial weapon. It's not just another clause, it is something where you can get business leverage and use it to the best of its, you know,
For instance, like
right.
if a developer is making an app, he's using his proprietary software to create that app. Now,
Yes,
just because he's created that app doesn't mean he's given up the rights to that software. So
exactly.
it needs to be very, very well worded to ensure that this kind of thing does not take place. That just because he's delivered a product, he loses the right to use that software in similar products.
Correct. And let us say features. You raised a very good example. So you're creating an app, and there are certain features unique to that app.
Yeah.
Now, what I'm doing is I'm giving you those features, but I'm using certain software and certain code to create those features for you. So if you tell me tomorrow, you know what, this is a product that is patented, and this is my idea. I want you to not use this code that you use to create my features for somebody else. Then that becomes a very tricky issue because you're within your rights to say, you know what, this was created for me by you on my request. So I have full rights in this deliverable or this app with these specific features. But then the question is, you are the one who used that software. You are the one who created that software, and you still have a right. Is that not in any way preventing you from using that software somebody else for somebody else there? So, and that's not uncommon, you know, in the world of IP, a lot of things happen like this. So then you get to go very granular and you question and you see, okay, what was the software I used? Okay, and what did I do to create this app? Then you make sure, and that's where you get to be a little creative and you say, okay, you know what? I will not create these features because they are created, you know, customized features based on your request. I will not create them for anybody else, but you cannot prevent me from using the software to create other features.
So the clause needs to be very carefully drafted so to ensure that this kind of situation does not arise in the
Absolutely. Absolutely.
post delivery.
Correct. And that is where, even as a lawyer, I myself found at sometimes a little confused and out of depth because we are talking IP, which is in a very technical subject, especially the world of patents. You have
Absolutely.
so many technical requirements, technical specifications to consider, and then there's something called prior art in the world of intellectual property, which means you need to know whether this already existed in the past, and there's a whole entire database which you can use to check prior art, and that's a completely different world in itself. So IP is not simple. So which is why I raise this as one of the top topics because it looks simple, And it's easy to say, you know what, in the world of startups, it's like, "Arey, yeah, let's just get the job done. We'll discuss IP later." You'll never get that chance later.
That
So you've got to be
conversation
very
quite
careful right
comes up.
away. Right. So then moving
So
on to a few other clauses which don't look as important or as I would say fancy as IP and the indemnities, but they're very important. Is Of late we've seen force majeure making news, right? This was one of those clauses that was just standard template document. You just take copy paste it, put it in there, saying in the event of force majeure, the parties are not liable. They have the right to suspend their services. Blah blah blah. But then COVID in 2020 changed everything. Why is that? Because everything in the world came to a standstill, including ships docked in harbors elsewhere, manufacturing units closed, supply chains were suspended, and people waiting for their raw materials, suppliers, employees were left waiting, and there were huge losses running into billions of dollars, if I'm not mistaken. And this was quite protracted. It was not a week or two, it was for months on end. If I'm not mistaken, more than a year before things started slowly coming back to normal. And that was when companies started looking at their force majeure clauses. And what they realized was this clause, though you had the force majeure clause, it was practically useless. Why? Like I said, like I just mentioned above, force majeure is an event which involves something called act of God, which is things like natural occurrences like earthquakes, floods, or huge thunderstorms. But it also includes man-made events like wars, riots, internet outage, power outage. So this includes acts of God as well as man-made events. The pandemic, of course, today we find that the pandemic has become a big issue in force majeure clauses. But despite all that, you find that force majeure was so broad, so vague, it was practically useless for anybody. So a few things you need to look for when you're discussing force majeure is, even today, let's say you have clauses, contracts older than 2020, go back to those clauses. If there are still agreements valid and existing today, if those engagements are continuing, the first thing you need to do is go back and look at the clauses and change them to reflect today's changed scenario. And how do you do that? Firstly, you identify those force majeure events by name to the extent possible. Obviously, you can't name everything, but now that with the experience and the benefit of hindsight, we can name a few of those events. And then you say, what is the result of that event? Okay, earlier force majeure meant, okay, I can suspend my services, I can suspend my payment, and wait until that event is resolved. But today, that's not the case. You need to first identify, okay, what is this event, what it meant for me. Was a riot the reason why I could not get the material, or was there some other way I could get the material? So you find out the event, the force majeure event. You discuss the effect it has on you, and three, you find out, was there any way you could have remedied the situation, or you could have mitigated the situation? Let us say because of riots or war in one country, you're not able to get some material which has to pass through that country. Now, what you do, you say, okay, did I try to go the land route or the sea route and try to go for alternatives? Did I do any reasonable effort to get that particular raw material? Did I do my best to mitigate the scenario or the situation? Okay. And then you see that you've done all that, or making sure that the other party has done all that, and then you say, okay, if this is a real force majeure scenario where we were not able to do anything, then this is how we will be responsible, and this is what our obligation is going to be. Make sure you define it further and further to within reasonable limits, and and just use logic when you're discussing these clauses to
because
ensure that.
very frankly, if a force majeure contract does not require the other side to mitigate, there is no obligation to. If it's a very vaguely framed force majeure clause, the other party can just take advantage of the vagueness and say, "I was not required to mitigate my losses. It's the force majeure event that took place."
Here's the thing, in the world of contracts, the law of contracts, certain things are assumed. You could be signing, you could be two parties who are consciously signing voluntarily to certain terms, but let us say the contract is silent on certain things, like you just mentioned. The law steps in and assumes certain things to the benefit of the party that is aggrieved. Like, for
Yes.
instance, you just said, I'm going to keep it vague because I don't know how I'm going to act when something happens. I don't want any risk. I don't want to take on any loss. I'll just push it on to the other side. And then if I have shown that, there was a force majeure event, but that was not final and that you could do something about it and you did not do it, and I suffered a loss, obviously you will still be held reasonable. And for that to happen, you know what's going to happen? If it's not in the contract, you will have to go to court. And then, expensive litigation, lawyer fees, loss of time, there's chaos in your operations department, loss of business, whole lot of wonderful things begin to happen, which we don't want. So the best thing you do here is you get your contracts in place to the extent possible. Again, don't get paranoid about these things. Just make sure you're looking at it from a very logical
Yes, of
perspective
course. You can't like cover
and
every
proceed.
eventuality, but you can be prepared for the worst case scenarios and try to avoid those.
Absolutely. And that's the reason we need to identify where the problem lies. And very often, like I said, in the Pepsi scenario, they didn't even think that somebody could come and challenge them on this particular advertisement, which was meant to be a joke. But then they had massive losses because of that. So the idea is just to be a little mindful and understand that we are in changing times. Today's world, there are two things that are against us. One is the extreme levels of technological innovation. I say extreme because we are living in very interesting times and technology is building on itself. So the rate of innovation has become exponentially higher, which means higher risks. And two, there is, there's a bit of the fear of litigation is gone in the sense people have become slightly more litigious. Not so much in India, maybe, but overseas. Some societies and some economies are quite litigious. They don't hesitate to go to courts. And thirdly, we are no longer a domestic economy primarily. We have a lot of international engagements. We have a lot of international contracts. The average Indian is today very easily working with somebody in the US, UK, or Europe. And these are economies who have a good knowledge of litigation. They're used to what litigation is. And
And also, they don't have the kind of backlogs we do in India.
oh, you don't know. Trust me, they have their own problems. Rest assured on that. So the point is, you got to be very clear what you're agreeing for. Don't assume. If you think you understand, good for you, but maybe you don't understand unless you're a lawyer. Why I'm saying this is contracts may be written in English, but trust me, it is not plain English. The language used in contracts sometimes uses terms of art, words, phrases, which don't mean the same thing in the court of law as they do in general conversation. I'll give you an example. When you're in an advertisement talk, you're saying, you know what, I'll give you industry best standards, or I'll give you the latest technology. That's something we see often, right? This phone carries the latest technology, this camera carries the latest technology. That's fine. The people understand it to be okay, it's the best I can get in the market today. But the moment you put that same phrase in a contract, what it does is it turns it into an obligation, a legally binding obligation. And what obligation is that? It does not mean latest technology as of the date of the agreement. It means for the life of the agreement. As technology keeps improving, you have to keep stepping up to match that improving technology. The latest technology as of today, regardless of when the contract was signed. So, what it means? Your obligation to maintain technological innovation increases without a corresponding increase in either fees or any other benefits under that particular engagement. So these kind of phrases and wordings have to be very clearly thought out, understood, and unless they give you something as a benefit, don't put them in at all. Make sure you and I always say your contract should be very cautiously worded, very conservatively worded, so that tomorrow, not today, maybe you're fine. Tomorrow, 5 years down the line or 5 months down the line, there is some dispute, and somebody else, a third party is looking at it, could be a judge, could be a mediator. If they are looking at it, will they interpret the contract the way you're interpreting it today? Or is there a possibility of them interpreting in a different manner? If there is, you're in trouble.
So this leads me very quickly to a part which we want to discuss about this. Is
Mhm.
that what are the things that a lawyer should be keeping, or what are the common red flags in a commercial contract that you should be flagging right away in case you're in negotiations over a contract? Like if the other party is giving you a contract to read, then what are the kind of red flags that you should immediately bring up?
Right. So these are what I would suggest, especially growing companies, to look for, because large companies have the advantage of in-house legal teams. But a few red flags, I would look at five big ones. We already discussed indemnities, LOL. We're done with it. Then intellectual property rights, they are done. Another thing I would look for is liability caps, and certain personal guarantees you're offering. Sometimes I've seen a personal guarantee being offered maybe in an NDA or in terms of execution. You say, my key personal who is working on this personally guarantees that he will finish it or he will do it to the best of his ability. No personal guarantees ever in any of these agreements. Okay. Secondly, one-way termination rights. What I mean is, generally, an agreement, no matter how equal an agreement looks, an agreement is never equal. In the sense, there are two parties, one of them always has a slightly upper hand, ever so slightly, if ever. Why? Because no such thing as equal rights and obligations. One party always has more clout, more power, more leverage, and that could change over the course of the agreement. But at the time of agreeing, you usually you see that when you're working with a market leader, you're working with somebody who is a government authority. You can't dictate terms to them. So they come in with some power and authority, and you need to work with it. So, especially in those cases, you see that termination rights are not equal in the sense they get a right to terminate for convenience. Anytime they don't feel like it, they can say, you know what, 30 days notice or 15 days notice, and we want to terminate this agreement. But you don't have that. And even if you do, you can only terminate for cause, and even those causes are very strictly defined. So what it does to you is you're stuck in a contract without a way out, and the other person could terminate the agreement at any time. This is bad in one way of, you are in the middle of a contract, you're a customer maybe, and you're getting to be dependent on the vendor, and the vendor or the service provider terminates for convenience, and you're left high and dry halfway through, no way to complete, and you've sunk a good amount of capital into this project, and you're stuck midway. So you try not to give the other person right to terminate for convenience. If they do it, you also take a right, equal right. But then, like I said, probably that may not do much for you. If you're a service provider and you have the right to terminate for convenience, not much, because you'll only be cutting away your own stream of income. So you got to be a little careful about putting these things in place. Just make sure that if they're terminating for convenience, it is not at a time where you're at your vulnerable. So, have some triggers that are viable, triggers that are very stringent, so that there is a good reason for them to terminate for convenience. And termination for cause, of course, you got to define those causes again, like breach of contract or multiple breaches, and you have not remedied the breach in time. So those are good reasons to terminate. But otherwise, clauses which offer you outright blanket right to terminate, you got to be a little careful. That's another. So the third thing is scope. So there's something called scope creep, a word we use in the world of legal reviews and the world of law. That is, it could be a scope you're defining for your statement of work. It could be the scope of the indemnity clause, or anything else, where you're defining, these particular elements will come within the scope of this engagement, or these are the things which I will be responsible for. I will indemnify you no matter what. Keep it again. Avoid keeping it vague and broad, because If you have not defined your scope, especially statements of work, if I can give you an example, let's say you have a statement of work which is creating maybe an app, like you said, for a customer, and then creation of that app requires a certain amount of expertise and a certain amount of work. Now, with that, what happens? You have identified the scope, but that is pretty broad. What over a period of time, what happens? And usually there's this clause that says they shall reasonably cooperate with the customer or reasonably cooperate with the vendor to make sure that the project is executed properly. So, what is that reasonable cooperation? So, that's a vague word, and anything and everything can fall into that definition. So, remove words like that, which looking at from a very critical perspective, you have no way of identifying or checking to see if that really works for you. So avoid vague terms, and that is when this the scope tends to kind of extend beyond what you initially agreed, and there that is where you see losses, you see falls in service levels. Let us say, and this goes both ways. You're a vendor and you're offering service levels to your customer, and then the customer slowly starts adding to your service level requirements with no additional pay, no additional time, no additional personnel given. So what's happening? Your service levels will start falling. Why? Because the scope of your service levels have increased. And then one fine day you see that your levels are falling, your customer is giving, penalizing you, and then you have no way out of it because it's a contract you can't terminate for convenience. And you want to terminate for cause, there is no cause because the scope has not been defined properly.
Absolutely.
Right? So this is how you got to look at these contracts holistically, consider all the perspectives involved, and it's basically, there's a saying, you don't lose the view of the woods for the trees, and so also the trees for the woods. You got to look at every clause, every word in the clause,
In
understand what the
relation,
purpose of that clause is, and then look at them from the larger contract perspective to make sure, okay, they have a place in the contract and they serve a purpose, and that purpose is something I'm okay with.
so
No
quickly
discrimination.
segueing to something else what that came up while you were talking about this. Like,
Mhm.
so what do you do if somebody says that this is non-negotiable for me, that this sort
Right.
of this contract is non-negotiable? What do you do in such a circumstance?
Okay, first things first, much as we like to say the person is not letting me negotiate, there is no such thing as a truly non negotiable contract. What the other party might be saying is, I don't want to negotiate. Why? Why? Because I'm a market leader. Why would I want to negotiate with you? Right? Secondly, I'm a market leader. I have a lot of products to sell, and my products are all over the world. Imagine, let's say, a computer manufacturer worldwide, world renowned, headquartered in maybe California, and they have products all over the world. They're selling the same laptop with a few variations across the world, and they have millions of customers, and they have one standard agreement that will speak about whatever rights and obligations. I'm just giving a simple example. This is not a B2C agreement I'm talking about. I'm talking about a scenario where you're working with a market leader. And there are some companies which are notorious for not changing even a single word in the agreement. It's happened. So the reason they don't want to encourage this is it's going to open the way for a lot more customized agreements. And with your products flying all over the world, you cannot afford to have that kind of different kinds of agreements for the same product. So that's one reason. And I think that's a reasonably good and genuine reason why some companies don't want to negotiate their contracts. But again, that does not mean that if your particular scenario or your particular engagement with them has a good reason that you should not negotiate. You should negotiate. Just because they say they don't want to negotiate does not mean you cannot. What you could do is make a request for negotiation and explain to them why you need that document negotiated. Let us say they come back to you and say, no, this is it, take it or leave it. Then there are a few things you could do. One, try and understand what their leverage is here. Understand what your leverage is. If they're a product uh, buyer, sorry, if they're a product manufacturer and you're a buyer, you're buying something from them. Could they as easily go elsewhere and get their product sold, or are you giving them a great entry into the market? So find out what your leverage is and try and use it, or explain to them that you have great disadvantage in doing this and you will have to walk out of the agreement. Sometimes it's good to walk out of an agreement when you have no option. But the other thing you can do when they say, no, this is what we do, we cannot encourage your request for a negotiation or any change, is nevertheless go ahead with the legal review. Review every single clause of the agreement, review it as if the other person is going to negotiate it with you. But then you highlight all these to your business teams. Why? You may not get the negotiation, you may not get the contract to your terms, but you will have identified all those risk factors in the agreement which could otherwise come back to bite you. Right? Then what you do, you look at these clauses and you say, okay, am I okay with an unilateral indemnity where I'm giving indemnity, but then am I okay with uncapped liability or maybe unequal liability caps? Am I okay with it? Or am I okay with not claiming any indemnity and IP rights? Am I okay with governing law and jurisdiction of some other country? So these are the things you look for, and then you identify, okay, am I okay with this? Yes, no, and then you find where you stand. Then you make a call. Then you say, okay, I am fine with this agreement, or the business says, okay, these are the risks we can take, these are the risks we cannot take. Then what you're doing is you're taking an informed, considered decision about that contract, and you're walking into that deal with your eyes open. And when some things do go wrong, you already have your eye on them, and you're ensuring that either they don't go get worse, or you're preventing such difficulties right at the beginning. So that's one
So
way
you're
you approach.
prepared in case something goes wrong. You at least know that this could go wrong, and you
Absolutely.
prepare
That's,
yourself.
you're being aware of what might go wrong.
Now, another question that comes to mind that I would like some clarification on.
Yeah.
In your experience, what is the most dangerous clause that is most commonly skipped over, but which any common business lawyer worth their salt like you would definitely flag?
Right. So this is quite an interesting thing because until a few years ago, when I didn't really look at this clause as potential danger, and this is the survival clause. It's usually one of those very small, innocuous statement which is part of the miscellaneous section of an agreement, which says these terms or the following clauses shall survive the termination of the agreement. What it means is clauses like confidentiality obligations or payment obligations shall not terminate the moment the agreement terminates. Why do we have these clauses? Let us say we have a 1 year agreement for some service, and at the end of the service, the agreement terminates on 31st December 2025, and invoice is raised the same day, and you have payment obligations where you're getting your money back in 30 plus 15 days, whatever you have agreed to in the contract. But then, as of January, your contract is no longer valid, or no longer alive, so to say. Does it mean you will not have right to receive the payment? No, you still get payment, right? You still get the money paid. Why? Because you might say, oh, it's a good faith thing, this, that, and the other. But the fact is, there are certain rights that you have accrued in the course of the agreement, in the natural course of entering into a contract, which have to run their own course regardless of whether the agreement terminates or still exists. Payments is one of them. Uh, then you have confidentiality obligations. They are another. Intellectual property rights. So I might have come into some confidential information relating to your customers or your IP or something else, which I have with me, and I would still agree to delete all information and share it or give it back to you. But still, we do maintain some records, and some of the information is still lying with me. I have an obligation to retain that information in confidentiality. Now, why is this a problem? We're talking of certain clauses like intellectual property, indemnity clauses, confidentiality, a non-compete, non-solicit. This is a big one again. Again, one of those very simple clauses. But all these are usually some things audit rights you see in this survival clause where they say, despite the agreement terminating, these will survive. Now, the problem with this sentence is nobody nowhere mentions how long they will survive. How long will your confidentiality obligation last? Your NDA might say it's for 2 years, but then what if it's an intellectual property right, an IP obligation, where you're holding something that is still relevant in today's market? So it becomes, a perpetual obligation. So let us say 5 years. No, agreement ends on 21st December, 25th. Sorry, 25th December, for example, 2025, and then in 25th December 2030, someone says, you know what, there's a breach of this. Oh, you know what? We remember we gave you that information 5 years ago. Come on, we're going to claim some damages from you. So that's a danger you would not have foreseen, you would not have expected, because the contract is out of your mind. It's been 5 years, but the obligation unknown to you is remaining. So this is one clause where I would, and always tell my clients to look at closely. Be very careful what kind of clauses you're including in this survival clause. You define them again by you define them by scope, by time, or by region if you must. In case of non-compete, non-solicit, you can't have a worldwide ban that you can't solicit any of my customers. That's not a workable alternative. You limit it to such an extent that it becomes viable, and that also becomes something you can justifiably ask. Let us say there's a breach. You can go and tell the courts, you know what? I said these guys, they should not hire my employees for a period of 1 year, 2 years in India. So that's a reasonable request. Otherwise, the courts will still dismiss them as being too vague, too broad. So these are the things you need to be really careful. And in the survival clause, largely you would see things like confidentiality, maybe payments, intellectual property, non-compete, audit rights, even dispute resolution clauses. Arbitration, for instance. You don't want to be forced to go into arbitration if you don't want it. So, and how long after termination do you want to be forced to go in? Again, you have to limit it. So that's one thing I've seen. Always avoid vague phrases, and make sure that there is no forever or access in perpetuity to the other side, to your either records, documents, or your work product, so to say.
So all these that you mentioned, this is just underlining the importance of having a proper legal review of these contracts, right? Like
Right.
if you don't have these things properly reviewed, it could be disastrous especially for a growing company or a startup. It could be absolutely disastrous, right?
Absolutely, because the pity is you don't know what you don't know. When you know these are the things I need to look for, you're looking for them. When you don't know what this is, you're fine with it. You're saying, oh, you know what, this is standard clauses. Everybody has it. Every agreement has this. Let's agree to these terms. You never know which term might come back to haunt you later. And that's why at the beginning I mentioned, and I think it bears repeating, is there are some of the stalwarts of the contracts, indemnities, LOS. Everyone, even non-lawyers, know about them and they look at them. But every clause in the agreement has the potential to become a quiet killer, so to say. Your non-compete clause sitting somewhere in your miscellaneous section could one day blow up in your face. So this it's very important to make sure that you know what you're reviewing. Again, remember, contract language is not everyday language. You need to have somebody who is used to reviewing it, look at it, and you could do it yourself, but then be ready to face the consequences. And the risk is not just monetary loss; it is loss of future business, loss of reputation, especially if you're a newcomer. Even worse if you're an industry leader, like what happened with Pepsi. What it does is litigation. People may not connect the two, but litigation also is closely tied with insurance. The moment you're hit with some litigation or any claim or any dispute, your insurance premiums increase. Just like having an accident and having your car premiums increase. Everything is connected. So make sure that the more conservative your documents are. I'm not advocating for extremely conservative documents. All I'm advocating for is a conservative approach to reviewing these documents, where you don't let things fly past the radar, or go under the radar, simply because you don't know what it means. If you don't know what it means, get someone who knows what it means. If If they don't know what it means, or even the lawyer says, I have no idea what it means, I have no idea why it is there, remove it. Negotiate. And then every single, you understand every single word and clause in the agreement. You know what it is there for. You know what it is doing. You know what it means for you, whether it's an advantage, a disadvantage, an obligation, a right, and what you can do should the contract go bad. Can you really assert what you're mentioning in the contract? You say, I have IP rights. Okay, fine. So tomorrow you breach the IP. Do I have a right to assert those rights? How can I assert those rights? What are my remedies? These are the things you will think back. And the more clear your contract is, I'm not saying make it verbose. You don't have to have a 100-page contract. But to the extent you have these clauses mentioned, or you have these rights and obligations mentioned, make sure they're clear. And that's usually done with legal advice. And that is why you're saving a lot of money by going for the right kind of advice.
So that's the entire thing. Sometimes there might be a 100-page contract which is completely vague, and there might be a 2-page contract which covers everything, which is
Absolutely.
very.
Well said.
So that's the
Very
thing.
true.
So I think we've done a good job of covering the things that could go wrong and what could go wrong, how it could go wrong, and I think at the end of the day, I think you said it very well when you said you don't know what you don't know, like you don't know what can go wrong and how it can happen. So yes, you must be prepared, you must be ready to face the consequences, and you must be and to be forewarned is to be forearmed. So if you know from before that this can be the issue, you can, when you actually face it, you're ready to deal with it. And I think that's something with it. Like what would you say? What else can be possible things that our audience can take away from this discussion today?
Well, like I mentioned, understand what the quiet killers are, and understand that every clause has the potential to be a quiet killer. That's one thing I would say. And one thing is I've created a small checklist for the audience, so I hope that will help them. That's basically again giving a gist of what we discussed. And if I can recap what I've said without adding anything more, it is this: your contracts are legal obligations. The moment you sign on a deal, on an agreement, you have no idea what you're setting in motion. If the contract goes well, and as lawyers, we're not drafting contracts for a deal that is going well, we're drafting contracts for a deal that might fall through, for a dispute that might occur. And that could happen when you're not in the picture. That is when the lawyer is not in the picture, somebody else is in the picture. We have agreements where you got some lawyer to draft and some other lawyer is looking at it 2 years down the line when you're having a dispute. Will that lawyer be able to interpret it clearly and unambiguously? So the idea is make sure you have clear contracts, unambiguous, not open to interpretation, and you know what you're having in there in the contract. You're getting a proper professional to look at it just to avoid confusion. And more important of all, don't assume when you don't know something. Don't assume this could be it. And this is I would say an unconscious bias we all have. When we don't hear what someone is saying, we try to fill in from the knowledge we have. Oh, they might have said that. That's something we do all the time. You extend the same thing to contracts where you say simple things like survival language now. We know this says this, but I don't really know what it says. No, it's a confidentiality. Yeah, okay. We have an NDA. Fine, it must be okay. Let's go ahead and let it survive the termination. So you're assuming so many things here. And when you're assuming things, what's happening? There's already a disconnect between what you're assuming and what the other side is assuming. And if that other side is looking to create trouble, things can go very bad. Or the other side again, people have moved on. People have moved on in your organization. 2, 3 years down, there's some issue, some dispute, and then you're not able to understand what the contract says because you're interpreting it differently. And then you go to the judge, or you go to the arbitrator or the mediator, and that person looks at it and he's like, you know what? I think this means something else. So where do you stand? So the one thing I would say as a takeaway is be very sure what you're putting in there. Don't assume, and whatever you're putting in there, make sure it is clear, ambiguous, and to the extent possible, highly defined within set parameters, so that there is no creep, or I would say you're not letting anything else, anything other than what you've promised as other obligations or rights to creep in to that particular clause.
So I've got a question from Amit Gupta on LinkedIn. He
Mhm.
asks, what can a business do when they face oligopolistic barriers? Because he says that oligopolies are becoming very clear, very common nowadays. So how do you what do you do when such thing happens?
Well, the first thing I'd like to know is if he can respond. Who is he here in the picture? Is he a small business player or is he a customer? I'm assuming he's a business player.
I'm
Let's go with
assuming it's a
that.
business because he's asking about business communities, how they can face it.
So now you're a small business, and let's say you have a store, a chain of office supply stores, and suddenly Reliance has come into your town and has purchased those, and your small store is now suddenly facing competition because of pricing and other issues. Well, the one thing you can do is you have the Anti-Monopolistic Policies Act, and you go and fight in the courts. That's one option. The other option is you don't have an agreement with any of these companies which promise you that they will not enter into the market. You don't have any, I would say, privity of contract with them where you can claim, say, you know what, you breached my contract, you breached my right to do business here. No, the remedy lies elsewhere. First one is go to courts. One of the claims is, you're swallowing up the small businesses by coming in with huge capital. You have the big names coming in small. It's happening all over, and that's not a nice thing, but I see that happen all the time. And just join together with other small businesses who are suffering as you, and then seek redressal. I think that's the one way you can go about it. You need to just
And
get together with similarly
yeah,
affected individuals.
I think that's pretty much the only option that you have in that
Yeah,
scenario.
yeah.
And I think there's another very interesting question that Dr. Ghosh has raised.
Mm-hmm.
Like, we use past judgments for arguments and things like that. So that right today it's the age of AI, right? So AI is a buzzword all over the place. So it's a temptation for I suppose it's a temptation for a lot of companies to just put their contracts through AI. So but it should be, isn't that a major danger that can arise if that is the case? If someone just runs it through AI and asks the AI to look for potential problems.
You know what? That's a very good question he's raised. I say it's good because do you think people are not using AI as of now? They are using it.
Yeah,
The
using it.
question lies in, or I would say the problem lies in how you're using it, what AI tools you're using, because we have a lot of AI tools, even in the world of law. Legal tech is a big business today. Why? Because we're all using AI, but the question is, what are you using it for? How are you using it? If I'm asking AI to say, create my written statement or a petition, okay, or a response to a petition, and then I just copy paste it and then print out and then go to the judge and put it in there, I'm asking for trouble. We had a recent case in the US where a lawyer ended up with fictitious cases which the AI had supplied him. So that's, of course, unfortunate and rather silly. But if I'm using the AI to tell me, you know what, I have these contracts, I have a database of contracts, run through the entire contract and tell me which were the biggest sticking points in my contracts, where we negotiated, or these are my business policies, these are my best case scenarios for my contracts. Let us say again, for payment terms, for example, I would prefer payment terms of maybe 15 days plus 20. Aspirational, yes, but I can ask for it. My business says 25, 30 days is okay. If I get in within 15 days, that's good. But I've seen that most of my clients pay me only after 45 days with a 15-day or maybe 30-day grace period. So identify all those clauses where I'm getting, all those contracts where my payment terms are bad. Or, on the contrary, I would ask, give me those clauses which are bad for me, which are posing huge risk. AI can crunch that data and give it to you. And that's, I think, a very useful and a very intelligent use of AI rather than saying, draft this document for me and then I'm going to send it as it is. So AI is
I
a
think
great tool,
I think
Shayak, from people I'd like to
danger is when you try to replace the human effort rather than supplement the human effort.
exactly. AI is an assistant, it's not a peer. Please remember that.
Absolutely.
You still need human intelligence. That intelligence is still artificial and it needs to grow a little more before it can replace, and I don't see it happening any sooner. But yes, human intelligence is still required to use AI, but it's an excellent tool. I mean, I've seen massive changes in using AI.
So yes, we've got a few comments from people saying that we should be definitely we like having they like appreciate your sharing your knowledge, and also one of the key points that you raised, that not letting anything open to interpretations. I think that's something, especially which has been commented, that it's a very key focus that you should look at, and that's something that they've taken away from your discussion. So I think it is coming through that what you are trying to warn about. I think that message has been well received in
So
that
thank you
regard.
so much, Shrek, and thanks for the audience. I'm really glad I'm able to send the message across. It is the need of the day because these are avoidable mistakes, and it would be a pity if we end up making the same mistakes. There are bigger mistakes we can't avoid. We might as well do what we can with what we can avoid.
And Indian Chamber of Commerce says they have some questions, but I don't have any. I don't know how to arrive at these questions. So, Dr. Ghosh, if you could step in and ask, perhaps if you have any questions.
No, no. I just wanted to. I just understood that we need business lawyers, but uh, while to evaluate drafts, otherwise it's impossible. We are bound to make mistakes. So that is very much clear to me. But my question is, how many are business lawyers? And I mean, what is the proportion of distribution and specialization? Business, marriage, criminal. I mean,
It's hard to say
are you
how.
are you the
I
majority?
would say there are enough and more commercial lawyers to cover the needs, but it depends on who you're comfortable working with, honestly, because why both you can ask Kalpana ma'am and myself to review a contract, but with her, she brings a different expertise, I bring a different expertise, and
Right,
it depends on what your relationship to us as lawyers is. So it would depend really greatly on who you have a relationship with as a lawyer and how you feel comfortable working with them. So I think that would be the main thing in
right,
this regard.
right. And Dr. Ghosh, if I could add a very humorous twist to it, it's like, who do you go to for your eye problem? You go to an ophthalmologist. Who do you go to for your foot problem? You go to a doctor who deals with foot problems, podiatrist maybe. Bones, you go to an orthopedician. So, that's the way you go to the expert for that particular area of concern. And most lawyers working in the IT sector or the world of business have a good idea of business. And those in litigation have a very strong concept of litigation and the rules, and the approach there is slightly different because people have already fought and they're in a very adversarial state of mind. So that calls for a slightly different set of skills as well. But yeah, um, you just go
So
depending on
then to evaluate a contract on blockchain, you have to go into the technicals of blockchain.
Yes.
to the extent
Into
possible, yes.
As far as
And we're
possible,
doing
we
it
would like.
already because when you're looking at, let's say, tech licensing, are we not discussing intellectual property concerns? We're discussing patents. We're discussing software code, escrow, code escrow. So it is very much involved and required, I would say, but to the extent possible. Now, I cannot become a blockchain expert, but I understand blockchain from a legal perspective.
understood. Anyhow, now we are at our end of the media team. Do we have any other questions, or then we can end the program? No, there's no other question. Then we would have we may end the program now. We are overshot by a lot, but still we enjoyed it. Thanks.
Thank you so
Thank
much.
you so
Thank
much.
you so much. Dr. Ghosh. Glad to hear that. And thank you all for being such an engaged and thoughtful audience today. I'd again like to thank the ICC, Dr. Rajeshri Ghosh, and Shayak for this opportunity. So, one
Thank
parting thought I would like to share with you is contracts and legal uh, work may seem dry on the surface, may seem like trouble, and you're better off keeping it away. But the consequences of ignoring them are anything but dry. So I hope this session helped you understand and spot the subtle risks that hide in plain sight and gave you some practical tools to take back to your business. There is a free takeaway checklist, which is, I believe the link has been provided. Please use that, and I hope you will find it useful. Thank you once again for your time and attention. It's been an absolute pleasure being here. Thanks.
Thank
you.
Thank you, Shai. Have a good day.
Thank you so much.